Imagine working for 4 years at Yale, acing every midterm, and then waking up one November morning to find the internet calling you the Halloween rapist. Your scholarship? Frozen. Your dorm key? Deactivated. Your life? Steamrolled before finals weeks. This is the opening scene of Saif Khan's 8-year-long legal odyssey, a story with more twists than a law school outline footnote, and yes, a script that might just change how every college in America handles Me Too accusations. Unlike Yale, here at Uncivil Law, we believe everyone is innocent until proven guilty, even on campuses that treat due process like an elective. Our job here today is to lay out who did what, who ignored which constitutional speed limit signs, and why Yale now faces a 9-figure court bill that could buy every undergrad a year of free textbooks, even at those New Haven prices. So we need to flash back to Halloween 2015. Khan, who is a STEM whiz born in Afghanistan, rocks a Mozart costume and escorts a fellow student, known as Jane Doe, back to her dorm. She's drunk, he's tipsy, and they hook up. By breakfast, her tale has spun from a spooky fling to he raped me while I was blacked out charges. She filed charges with campus police and takes the matter to the administration, who produces academic discipline in what can only be described as a star chamber. Yale's response, as predictable as it is tired: an immediate suspension, eviction, and an email advising Khan to get out by lunchtime. Because nothing screams presumption of innocence quite like locking the accused out of that Wi-Fi. Fast forward to 2018. Courtrooms, judges, cross-examination. The prosecutors roll in with the emotional stuff. Defense unearths digital receipts. Jury breaks for lunch and comes back with a quick not guilty 4 times over. While the criminal process in an actual courtroom is everything you would expect, we have to talk a little bit more about that Kangaroo Court at Yale, Yale's university-wide committee on sexual misconduct. Unlike a courtroom, there are no oaths, no cross-examination, and no lawyers are allowed to speak for or against anyone. Khan isn't even allowed the courtesy of being in the same room as his accuser while she testifies. Khan has to listen in a spare room to a disembodied audio of his accuser, as if they're trying to simply grade term papers. Trying to imagine fighting a speed ticket when the cop doesn't actually have to testify and the judge won't even look at the dash cam. Not much of a due process. Predictably, our panel convicts Khan in the academic sense, and he's formally expelled. The degree he was once assured to earn in a simple semester now vanishes. But Khan, for his part, doesn't take the expulsion lying down. He sues Yale for breach of contract and Doe for defamation, asking for $110 million in damages. Yale's attorneys initially scoff, saying, "You can't sue, our hearing is quasi-judicial, and therefore there is immunity." A federal judge initially buys the argument, tossing Doe from the case. On an appeal, the Second Circuit scratches its head and punts the question upstairs. Hey, Connecticut Supreme Court, is a no oath, no cross-examined tribunal really courtroom-like for the purposes of your own state law? Connecticut's Supreme Court justices, interpreting their own law, read Yale's rulebook and practically spit out their coffee. Their unanimous opinion calls the process so lopsided it reduced Khan's lawyer to a, quote, potted plant. 5 key missing safeguards were identified: sworn testimony, cross-examination, legal advocacy, a record, and a meaningful appeal, meaning that the hearing wasn't quasi-anything. Translation: no immunity. Doe can be sued, and Yale's warm and fuzzy procedure just torched the shield meant to protect those accusers. Oops. Overnight, every university lawyer can probably be heard to be sweating. If a survivor's statements aren't automatically protected, schools now basically have 2 options. One might be to actually beef up that due process, or the second might be to warn complainants that they could get dragged into civil court. Either way, those billable hours will go up. And Khan finds these 15 national women organizations, which have filed amicus briefs in his case, flat out labeling him her rapist, using that cause to swing the court towards an absolute immunity for survivors at the expense of true victims like himself. The courts make these groups rewrite, but the original lives forever online in public view. And now podcasters and Twitterers of all political persuasions are arguing over the implications. Khan's immigration status also hangs by a thread amid it all. His student visa would die if he's expelled. ICE initially tried to snag him at a courthouse, their body cam as they try to tase him when he makes a break for it. Only after much public outcry does a judge tell ICE they can have him back when they can engineer a better win and bond is granted. Immigration remains a work in progress on this side of the southern border. Still, with ICE having not secured Khan for the moment, much hangs in the balance for Khan as ICE and Yale together seem to act to drag him up to the edge. So let's recap. The criminal justice system, Khan is fully acquitted in a full adversarial trial with full due process rights. And Yale's tribunal, Khan is found guilty without sworn testimony, cross-examination, or even without the ability to face one's accusers, as Khan was sidelined to a room merely to hear the audio. Connecticut Supreme Court was so outraged, it said that Yale's secret process failed fundamental fairness, allowing both Yale and the accuser to be sued. As for the federal district court, the case is now proceeding towards discovery. Khan, of course, has been rebuked online for daring to have the temerity to actually stand up for himself and say that maybe some women are not telling the truth. As for the larger issue here, universities have created this whole nightmare through their Title IX systems based on trust. Trust the complainant, trust the administrators, and trust the process. Khan's case shows the fallacy of all that trust and shows that universities cannot be trusted to hand out due process on their own. If even a Yale panel can't survive judicial review, after all, home to one of the best law schools in the world, what hope is there for other universities and their legal toxic waste? And if you're an accuser making up lies, you now actually have to worry about being held to be account because that false accusation can and should bring a lawsuit down on your head. After all, if you're a survivor and you're not 100% certain you're going to win, why take that risk? But as to those people saying those kinds of things, I simply say, what redress is there for those that are falsely accused in your universe? What this all seems to indicate is the comeback of some sanity to these vicious Title IX environments at so many universities that so many universities have formally used to convict people without due process. Now, of course, qualified immunity is still a problem. Khan has to show that Doe acted with sort of bad intent that would defeat immunity, malice in this context. But the facts here do seem to lean to that conclusion based on the receipts that Khan has. Even under rules allowing for a wide berth for good faith mistakes, universities are expected to handle sex and assault-related cases with actual sex neutrality to both parties. They aren't supposed to do what Yale seemed to do here, create a process that favors the woman at the expense of man. That is not the sex neutrality that Title IX demands. In the process, Yale undercut a key guarantee by jamming in a tag team of two instead of letting a neutral arbiter really see and hear both sides in a fair way. As for Khan himself, the civil trial could bring him compensation, closure, or both. But perhaps even more importantly, because of his influence, win or loss of trial, what he really gains is a reshaped debate. Title IX can't dodge constitutional gravity forever. Yes, previously the pendulum had swung hard towards believe at all costs, but now it's cutting back to a more balanced position towards a more verify or pay. But what do you think? Make sure to leave your thoughts in the comment section below. Do you think that Yale went too far, or do you think that they had it just right? Do you think this cutback is good for those accused, or do you think it comes back at too much of the expense of those making the accusation? I'd love to hear your thoughts. Until later, my friends, I've been Uncivil Law, and remember, keep it uncivil out there. Peace.